If you obtained U.S. citizenship through the naturalization process and recently you have been staying up at night thinking, is it possible for this to be revoked? You are not the only one. You observe the news stories. You observe the enforcement videos. You hear terms like stricter measures, removal, immigration reform, and suddenly something that previously seemed secure starts to seem uncertain. You put in effort for this. You prepared for the citizenship exam. You succeeded in the interview. You appeared in a courtroom and recited the pledge. You thought that occasion represented security, conclusion, safeguarding, so when immigration matters fill the headlines in February 2026, it makes sense to wonder, have there been any modifications to my citizenship? Is citizenship obtained through naturalization truly stable? Could enforcement measures possibly affect me? Today, we are going to distinguish concern from reality, news coverage from legislation, and uncertainty from constitutional truth, because there exists a significant difference between a more visible enforcement atmosphere and an authentic legal risk to your citizenship, and recognizing that difference matters completely. Hello, I'm Sophia and welcome to US Updates. My focus is on explaining immigration matters clearly, steadily, and accurately, particularly during times like this when concern moves quicker than reliable information. In this video, we are going to review step by step through what current immigration policy in February 2026 truly signifies for citizens who naturalized, what the Constitution ensures, what citizenship revocation truly involves and what it does not involve, and the realistic actions you should or should not consider right now. This is not about political positions. It is about legislation, protections, and understanding. By the conclusion of this, you will understand precisely where you are positioned, what is safeguarded, and what you can confidently stop being concerned about, and that understanding matters more than ever. Let us begin with the foundation because once you grasp this clearly, much of the concern starts to diminish. Under the United States Constitution, citizenship once legally provided is lasting. That is not a political statement. That is not influenced by who holds office. That is constitutional legislation supported by Supreme Court precedent, extending back many years. If you finished the naturalization procedure, satisfied the residency standards, succeeded on your citizenship and language tests, revealed the necessary information, and recited the Pledge of Allegiance, you are a United States citizen with the same constitutional safeguards as someone native-born in this nation. Your citizenship is not a temporary permit. It is not a permanent resident card. It is not provisional standing. It does not require renewal, it does not terminate, and it cannot be removed simply because immigration enforcement becomes more forceful or political administration changes approaches. Presidential directives cannot override constitutional safeguards. Changes in enforcement approach cannot rewrite the constitutional amendment. The legislature cannot approve a basic statute that suddenly removes lawfully naturalized citizens of their standing. Citizenship, once correctly provided, is not uncertain. It is one of the most powerful legal positions that exists in American legislation now. I want to stop here for a moment because this matters. Many individuals unconsciously transfer the concern they experienced as permanent residents into their experience as citizens. As a permanent resident card holder, your standing could be examined under certain situations. There were requirements. There were uncertainties. There were renewal obligations and movement restrictions. Citizenship is different. It is conclusive. It is a constitutional standing, not an administrative one. And if this kind of clear, fact-centered explanation is valuable to you, make sure you are following this channel so you do not have to depend on speculation or online discussions the next occasion immigration fills the headlines. Reliable information is one of the most effective forms of safeguarding you possess. But, and this is where we need to be exact, there is one limited legal exception that individuals often hear about without completely grasping it. It is called citizenship revocation. And this term alone triggers concern because it sounds like the government can simply reverse citizenship. That is not what it signifies. Citizenship revocation is a formal legal procedure that can only occur in federal court and only under very particular situations. The government must demonstrate that a person acquired citizenship through deception or by intentionally hiding a significant fact during the naturalization procedure. This is not about policy differences. It is not about switching political affiliations. It is not about opposing the government. It is about whether the original naturalization was legally legitimate. To satisfy that requirement, prosecutors would have to present evidence that someone purposely provided false information on their naturalization application, concealed serious criminal background that would have made them ineligible, utilized a fraudulent identity, hid participation in persecution or terrorism, or left out information that was legally significant to the approval determination, and even then it is not immediate. The government must initiate a civil case. The individual has the entitlement to legal representation. There is investigation. There are evidentiary requirements. There is a judge. The standard of proof is elevated. And historically, citizenship revocation cases are uncommon, time-intensive, and costly. They are not large-scale administrative measures. They are individual court processes that often require years to complete. This distinction matters enormously in 2026 because when individuals hear about increased immigration enforcement, some believe that citizenship could somehow be included in that enforcement movement. But citizenship revocation is not a policy instrument that can be broadened easily. The legal requirement has not modified. There has been no new legislation changing the standard of proof. There has been no Supreme Court decision diminishing constitutional safeguards for naturalized citizens. Even if an administration desired to pursue citizenship revocation cases more forcefully in cases of demonstrated deception, it would still be restricted by the same constitutional obligations and procedural safeguards that have existed for many years. So when you hear the term removing citizenship, recognize that in reality it refers to a limited court-based procedure connected to deception, not a political mechanism that can be activated against law-abiding naturalized Americans. So, if naturalized citizenship is constitutionally safeguarded and citizenship revocation is uncommon and deception-based, what precisely is occurring right now in February 2026 that is making so many individuals uneasy? The response is enforcement presence. The current administration has substantially expanded immigration enforcement activities. ICE activity is more regular and more visible. Detention measures are more rigid. Border enforcement has strengthened. Removal efforts are being emphasized for individuals who are without documentation or who have final removal determinations. That change in presence modifies how communities experience things, even if it does not modify the legal reality for citizens. When you observe workplace operations covered on the news, when you hear about significant removal activities, when online platforms amplify every enforcement story, it generates the perception that the entire immigration situation is unstable. But here's the essential distinction. Enforcement measures target immigration standing violations. Naturalized citizens do not have an immigration standing. You have citizenship. You are not in the group of individuals subject to removal processes. You do not need a temporary permit. You do not need to renew anything. Your legal relationship with the United States is fundamentally different from someone who is without documentation or even someone who is a permanent resident. This is where misunderstanding develops. Immigration policy discussions often get presented broadly: stricter measures on immigrants, strict immigration reform, new removal initiative. But those terms combine multiple legal groups into one emotional news story. A permanent resident card holder is not the same as an individual without documentation. A temporary permit holder is not the same as a naturalized citizen. Enforcement directed at unlawful presence does not legally extend to individuals who have completed naturalization. Yet when language becomes intense, individuals who spent years managing a vulnerable immigration system can instinctively experience like that vulnerability has returned. It has not. The language may be harsher. The enforcement may be more visible, but language is not legislation. Presence is not a constitutional modification, and intensity does not rewrite citizenship safeguards. Now, let us address 3 of the most frequent statements circulating right now, because false information develops in environments like this. The first statement is that large-scale citizenship revocation is approaching, that the government is preparing to remove citizenship from significant numbers of naturalized Americans. There is no legal procedure for this. There is no new legislation authorizing it. There has been no constitutional modification allowing it. Citizenship revocation, as we discussed, requires individual federal court processes connected to deception. It cannot be performed in volume through administrative measure. The second statement is that certain nationalities or religious communities are being singled out for citizenship removal. While immigration enforcement emphasis can concentrate on particular geographic areas or security matters, Citizenship revocation cases must be founded on deception or significant false representation, not race, religion, ethnicity, or political perspective. Singling out citizenship removal based on those characteristics would be unconstitutional and immediately challenged in federal court. The third statement is that naturalized citizens need to take urgent dramatic actions to safeguard their citizenship. Abandoning prior citizenship immediately, submitting special documentation, purchasing safeguarding services, or enrolling with organizations promising protections. None of that is required. Your citizenship is safeguarded by the Constitution, not by additional submissions or private services. Concern-based businesses often appear during times of uncertainty. Be careful of anyone requesting you to provide money to secure something that is already legally secure. Recognizing what is truly occurring and what is not modifies how you respond. There is a real enforcement change in 2026. There is a heightened concentration on undocumented standing. There is political intensity around immigration, but none of those developments modify the constitutional permanence of lawfully acquired naturalized citizenship. When you distinguish enforcement appearance from legal authority, the situation becomes much clearer and much less concerning. Now that we have distinguished legal reality from political disturbance, let us shift into something realistic. Not because your citizenship is in danger, but because understanding becomes even more effective when you understand what to do next. The first action is simple. Protect your documentation, keep your naturalization certificate in a secure place, make physical duplicates, and if possible, secure electronic copies stored safely. This is not because someone is approaching to examine your citizenship at random. It is because having immediate access to verification eliminates stress if you ever need to request a passport, replace documents, sponsor a family member, or verify your standing for any reason. Preparation reduces concern. The second action is recognizing your entitlements as a citizen. You have full constitutional safeguards. You have the entitlement to procedural fairness. You cannot be removed. You can move on a U.S. passport, you can participate in elections, you can request for family members. These entitlements are not symbolic, they are enforceable. Sometimes simply reviewing what citizenship legally provides you restores a sense of stability that headlines can temporarily disturb. Third, if you have family members who are lawful permanent residents and qualified for naturalization, this is an important moment to consider encouraging them to submit. Permanent residence is strong, but it is not the same as citizenship. Permanent resident card holders can still be placed into removal processes under certain situations. They must maintain residency obligations. They are subject to immigration enforcement regulations in ways citizens are not. Naturalization provides conclusion. The procedure itself has not fundamentally modified in 2026. It still requires physical presence, continuous residence, English ability, citizenship knowledge, and good moral character. But if someone in your family meets requirements, pursuing citizenship can provide long-term security that is particularly meaningful in an enforcement-intensive climate. If this explanation is helping you think more clearly about your situation or your family's choices, consider distributing this video with someone who might be quietly concerned but has not asked these questions out loud. Sometimes understanding spreads one conversation at a time. Now, let us discuss more complicated family scenarios because this is often where concern really exists. If you have relatives without documentation, the current environment is not favorable for ignoring that reality. Enforcement is active, removals are occurring. Undocumented standing carries real vulnerability, and hoping that presence will diminish is not a plan. That does not mean alarm. It means consultation. There may be options someone has not explored. Adjustment through family, humanitarian safeguards, exemptions, cancellation of removal, or other relief depending on the facts. But those choices are case particular and require a licensed immigration attorney to evaluate correctly. Speculation and internet guidance are risky in this climate. If you are sponsoring a relative internationally, recognize that family-based immigration remains legal, but processing periods may extend. Examination may increase, and policy adjustments could affect groups or numerical limits. Postponing unnecessarily can sometimes mean facing more rigid requirements later. And if you move internationally as a naturalized citizen, always move on your U.S. passport. The United States recognizes dual citizenship, but some nations do not. If you return to your nation of origin, be aware of that nation's regulations regarding dual nationality, taxation, or military responsibilities. None of those matters affect your U.S. citizenship, but they are realistic realities worth recognizing before you move. What all of this comes down to is this: your citizenship itself is stable, but your family's immigration situations may still require attention. Stability at the top of the progression does not automatically secure every level beneath it. Being proactive, not concerned, but proactive is the most constructive response to a high enforcement environment. At this point, you might be asking a very realistic question. Do I need an immigration attorney right now? And for most naturalized citizens with straightforward backgrounds, the response is no. If you acquired your citizenship lawfully, revealed required information honestly, and have not been contacted by the government regarding deception or false representation, there is no preventive legal submission you need to complete. There is no special protective action required. Citizenship does not need maintenance. It does not need renewal. It does not require defensive documentation. However, there are particular situations where consulting an immigration attorney makes sense. If you are sponsoring a family member and the case involves prior overstays, removal determinations, criminal background, or complex exemptions, you absolutely want professional guidance. If you have relatives without documentation trying to assess their choices, that evaluation must be individual. If you ever receive formal communication from USCIS, the Department of Justice, or any federal agency examining past immigration representations, that is the moment to seek counsel immediately. And when I say attorney, I mean a licensed immigration lawyer, someone admitted to practice legislation, ideally concentrated particularly on immigration matters and preferably connected to reputable organizations such as the American Immigration Lawyers Association. Be careful of anyone who ensures outcomes. Be careful of large cash requirements without written agreements. Be careful of notaries or consultants presenting themselves as attorneys when they are not licensed to practice legislation. Immigration deception increases in periods of uncertainty because concern generates opportunity. A real attorney will evaluate your facts, explain uncertainties clearly, and never promise impossible results. They will not tell you they can safeguard already secure citizenship for a charge. They will not create emergency submissions that do not exist. Legal guidance should reduce concern, not take advantage of it. Now, I want to shift to something that does not appear in statutes or court decisions, but is very real. Emotional impact. Many naturalized citizens carry years, sometimes many years of immigration-related stress. You may remember what it experienced like to wait for temporary permit approvals, to check case conditions online constantly, to worry about missing a document, to be concerned that an error could derail everything. That psychological mark does not disappear overnight just because you received a certificate of naturalization. So, when enforcement headlines increase, even if your rational mind recognizes that your citizenship is secure, your emotional response may react differently. You might experience a moment of the old vulnerability. You might examine something that is legally settled. That reaction does not mean you misunderstand the legislation. It means you experienced uncertainty for a long time. It is important to give yourself recognition for that experience. You managed a complex legal system. You satisfied the standards. You obtained citizenship lawfully. The concern you once experienced was reasonable in earlier stages of your immigration procedure, but the legal situation of your standing has modified. You are no longer in a provisional group. If you find that the current political climate reactivates old concerns despite knowing the legal facts, consider connecting with community. Speak to other naturalized citizens who share similar experiences. Connect with immigrant advocacy organizations that provide reliable updates. If stress experience is overwhelming, there is no weakness in seeking counseling support to process it. Security is not only a legal condition, and it is also a psychological one, and both matter. As we look at the larger situation in February 2026, it is important to distinguish two forces that often get combined together: political climate and constitutional framework. Political climate can change quickly, enforcement emphases can strengthen, public language can become sharper, media coverage can amplify every measure, but constitutional framework moves slowly, deliberately, and with high obstacles to modification. Citizenship falls into that structural group. It is anchored in the constitutional amendment and reinforced by many years of Supreme Court precedent. That foundation does not move with each election period, so when you hear sweeping language about immigration stricter measures, remember that those approaches operate within legal groups: undocumented standing, temporary permit violations, removal determinations, asylum qualification. Citizenship is a different group entirely. If you naturalize lawfully and honestly, there is no hidden procedure waiting to reverse that. There is no presidential shortcut. There is no quiet administrative action. There is no new 2026 statute that has rewritten the regulations of citizenship revocation. The legal requirement remains deception or intentional concealment of significant fact demonstrated in federal court with full procedural safeguards. Here's what we understand clearly. Immigration enforcement in 2026 is visible and active. Removals of individuals without documentation are occurring. Border and detention approaches have tightened. Policy discussions around asylum, work permits, and family-based immigration continue. But none of those developments modify the permanence of lawfully acquired naturalized citizenship. If you responded to your application truthfully, revealed what you were required to reveal, satisfied qualification standards, and recited the pledge, your citizenship is secure under the Constitution. That is not optimism. It is legal fact, so the path forward is not alarm, it is awareness. Stay informed through reliable sources like USCIS, the State Department, reputable legal organizations, and licensed immigration attorneys. Keep your documents organized. Encourage qualified family members to naturalize. Seek professional guidance when cases are complex. And most importantly, allow yourself to experience the stability you obtained. You have the entitlement to participate in elections. You have the entitlement to hold a U.S. passport. You have the entitlement to request for family members. You have the entitlement to reside here without concern of removal. Those entitlements are not symbolic, they are enforceable constitutional safeguards. And recognizing them fully is one of the most powerful responses to a turbulent political environment. If this video has helped you experience clearer about what naturalized citizenship truly safeguards and what it does not, make sure you follow U.S. updates. We are committed to fact-centered immigration guidance that eliminates false information and concentrates on what the legislation truly states. Distribute this video with someone who might be concerned, but has not had access to reliable information, and if there is a particular statement you've heard or a topic you want us to address next, mention it in the comments. Your questions help shape future videos that serve real matters in our community. Thank you for being here, and thank you for being part of a space where reliable information is treated as safeguarding, not political positions.